As you can see, the family of the late Top Cohen, presented by the sister, instructed us to file a petition for removal of the directly and viciously. We got instructions again to file another petition to the Judicial Service Commission against the Court of Appeal Judge Justice Ole Kantai. We have filed. We can confirm that the petition has been filed, and therefore we want the whole world and the public to know why the family of the late Top Cohen will want one Justice Ole Kantai to be removed. The grounds upon which one we have adduced is that Justice Ole Kantai is being protected by the Director of Public Prosecution. An act or an omission but is so grave to the conduct of the judiciary and the reputation of the Kenyan judiciary. We have tabulated serious grounds that meet the threshold to remove the judge from sitting as a judge. One is that during his time as an advocate, he is alleged to have forged documents, government documents, in the transfer of the shares of one Silas Ita to himself and later to Sarah Cohen. Two, we have compared the provisions of the Constitution, the expectation of what a judicial officer is supposed to be. This is provided for in the Constitution of Kenya and the Bangalore rules on judicial officers. What does the international rules on all judicial officers worldwide are supposed to be? One, a judicial officer cannot, shall not, will not participate in drafting pleadings for an accused person or for a litigant. Justice Ole Kantai assisted Sarah Wairimu to draft her statement. He assisted her to record a statement edited to the Director of Criminal Investigation that to us is assisting to draft pleadings, which is contrary to the provisions of the Bangalore rules. Two, Justice Sankale utilized government resources bestowed to him as a judicial officer. From Kisumu Airport, he picked his girlfriend using a judicial driver, a judicial car, from the airport of Kisumu to Acacia Hotel. How an authorized person, Cliff Ombeta here, cannot board Sankale's girlfriend was inside a government vehicle, a judicial officer. Third, under the rules of the Bangalore rules, a judge is supposed to be like Caesar's wife. Caesar was a Roman emperor. His wife, the protection, the ring around the protection of the wife of the president or the Roman Empire is 100 times the protection the Resi company of GSU gives the President of the Republic of Kenya. You could not be able to access Caesar's wife to seduce her. That is the purpose of that statement. How did Justice Sankale have extramarital activities when he's a judge? We do quite a number of family matters. Among the grounds that will go before the judge is a litigant arguing that so-and-so had extramarital activities with my wife. Does that person fit to be a judge of the Court of Appeal? What does Article 10 of the Constitution say? And Article 232 of the Constitution, the values and principles of good governance and public service. The judge, by having an affair outside his marriage, fails the test of Caesar's wife. And that is enough ground for him to leave. Lastly, before I give Cliff and Shadrach to say, another ground we have raised is if Justice Sankale is kept as a judge up to today, how does the judiciary, the image of the Kenyan judiciary, appear? Justice Mutunga at one time talked over a bandit economy. Justice Sankale sitting, presiding matters at the apex court is like now saying the Kenyan judiciary is completely a setup of people who are suspects of murder, who are suspects of extramarital affairs, who are suspects of misuse of public resources, and yet they are sitting before the judges. It is our submission that Justice Sankale should resign. The JSC should act with speed because the petition we have filed is sufficient enough for one, Justice Sankale to leave. Two, remember the nexus between Justice Sankale and one Nurdin Haji is coming to play now. That is the reason why that petition was filed. Please.
When a matter has been filed, sometimes it is good not to fight it. Sometimes it is just good to save face. It is going to be embarrassing for us to drag the judge through all this kind of mud. It is going to be embarrassing that the public gets to know this in advance and then you still stick in office. It's embarrassing that you will still stand there and say that you are a judge and while all this is going on. Sometimes it is good. It is important. It saves face to be able to do that. Sufficient evidence is there. Initially, I had my reservations about this issue. I have gone through the files. Being one of the lawyers of the family, I have seen the evidence that is there. I have seen the circumstances that are there, both direct and circumstantial. The only way that such evidence can be set aside, that can clear your name, is by you participating in the process. Not by preventing it, not by preventing it, but by entering that circle, by throwing your hat into the ring and fighting it. Clear your name. When it is said that you are on the night you are together with one of the accused persons where the deceased was, that you helped to do the murder, that you helped to get rid of the body, that you helped to secure the other hitmen. It's embarrassing that these kind of things should be said now. But then again, why shouldn't we? Why shouldn't we? The best thing then the judge needs to do is avoid all these things. Ask maybe for some time to step aside and get into the process. Because ultimately that is the only solution.